Good afternoon, everyone. Welcome to another section of our Facebook Live. My name is Adedamolabi. I trust we've been enjoying the stay at home with our family members, and I also believe it's been a time to bond with family members, children, husband, wife, and everyone around us. So, this afternoon, we'll be talking on COVID-19, that is coronavirus, and its legal implications on contractual obligations. And the section is going to be divided into some subtopics. So at the end of this section, I hope and I believe we will be able to have an informed information or informed knowledge on whether or not COVID-19 is a relief from existing contractual obligations. So under this section, we'll be talking on we have a general discussion on COVID-19. I believe we all have an idea or a full knowledge of what the virus is about. Then we also talk on the general law of contract. And we'll also touch on the exceptions to the general principle of contract, which we'll be looking at this afternoon. Then we'll also look at two major principles of contract, or two major um, policies in contractual obligations, which is force majeure, and we'll also look on frustration of contract. And at the end of this section, we'll talk on the reliefs or remedies that are applicable to parties as a result of COVID-19. So, by way of introduction, COVID-19 is an ongoing pandemic which was discovered in China in December 2019. And as at March 2020, the World Health Organization declared COVID-19 as a pandemic, having spread through over 200 countries of the world, not exempting Nigeria. As of today, Nigeria has a confirmed cases of 174, which we hope it won't rise. There won't be a rise in figure of the coronavirus, which everyone is praying right now. So, as a result of the pandemic, various government policies, guidelines, and laws have been put in place to curtail the spread of the virus. And some of these policies include, but not limited to, shutting down of countries, restriction of movements of people, total lockdown. We've had situations where people have had to be confined to their house. And since the breakdown, or since the government policies in Nigeria, particularly Lagos State, today has been a guideline on people working from home. Even Law Accent has been operating from home. And you can also see that this section is also from home. So these are some of the consequences of the corona. And another funny one is the fact that people have had to postpone engagements such as wedding ceremonies, burial ceremonies, and even surprise parties. No one has been able to spring up surprises. I can remember my mom she had an engagement in Ekiti, a burial. The burial was put on hold. So many things like that as people have had to suspend as a result of the pandemic. And this is not limited to contractual obligations or business activities or economic activities. And the pandemic is such that has drastically affected the economy of every country in the global village and in every country in the world. So this afternoon we'll be looking at the effects of COVID-19 on business activities, particularly with regards to contractual obligations. So going to the general principle of contract. The general principle of contract is to the effect that once parties to a contract have been able to agree after negotiation, once they've been able to agree on the terms of the contract, they've been able to identify the rules and obligations expected of contract, and they've also been able to agree on the commencement date and the due date for performance of obligations. Once this has been put in place, the principle of contract is to the effect that parties are binded by what they've agreed to do in their contractual agreements. So the principle of contract is to the fact that where there is a failure on the part of a person to comply with the provisions of the contract agreement, or even if it is not written, it can be oral, it can be in writing. So where parties have been able to agree, whether orally or in writing, on obligations of the other person or how the contract is to be carried on. Where there is a breach, the provision of the law automatically comes into place to the effect that the defaulting party is said to be in breach of the contract, and the other party can enforce the contract or can apply to the court to either terminate the contract or compel the other party to perform the contract, or even where the court is able to terminate the contract, the other party can also seek for a compensation in form of damages. So these are the positions of the law with regards to performance of contracts. But there is an exception to this principle of contract, and this exemption is where the non-performance or delay in performance of a contractual obligation by a party is as a result of supervening events, that is, superior events or activities which are beyond control of the party who is in default. So, for example, where there's an agreement to carry on a contract, and as a result of an event which the other person cannot control or has no power over, is unable to perform that contract, the law says such person is exempted from any from an action for breach of contract. And for example, aside the fact that there is an agreement to the effect that a person is expected to do or perform a contract at a particular date, we've also seen there are also cases where people are about to enter into a contract with another person, for example, for a construction engineer or someone who has leased a land to for dredging purposes. So where an agreement has been signed into by parties, let's say the agreement is that the arrangement is to be for a period of, let's say, 6 months, and going by the outbreak of COVID-19, people have been home for the past 2 weeks now in Lagos State, even before President Muhammadu Buhari declared a total lockdown of Lagos State. People have been at home in Lagos State. And we've also seen cases where in other parts of the world, so people have also been at home for the past 1 month. So for cases like this where people have not been able to carry out obligations in contract agreements, the law provides for exemptions where parties can be exempted. So these are things that we'll be looking at or considering this afternoon as regards COVID-19. Having said that, it is no longer in news, or it is not in doubt, or you will also agree with me that the outbreak of COVID-19 has put a stop or has suspended so many business activities, and even people have had to cancel activities or cancel engagements due to the outbreak of the pandemic. So this afternoon we'll be looking at the way out, or if any, the way out if any, and if a person can actually plead the fact that COVID-19 has been a bar or has limited his ability to carry out contractual obligations. But before we go on to whether or not COVID-19 is a pandemic, or whether or not COVID-19 is something that can relieve a person from contractual obligation, it should be noted that when a party is seeking to rely on a superior force or an act which is beyond its control, and it seeks to rely on it as an excuse for not performing what is expected to do in a contract, the person has a duty to create a nexus, that is, to establish a relationship between the said act and non-performance. So if you are saying coronavirus um has been a stumbling block to you performing your contract or performing an obligation in a contract, you need to establish or make known to the other party what coronavirus has actually done. So it won't just look as if it won't be a situation where you are just relying on coronavirus as an excuse. You should be able to establish the fact that the outbreak of the pandemic has actually limited or restricted you from performing your obligation in the contract. So at the introduction of this section, I talked about the fact that I'll be looking at two basic elements, which is force majeure and frustration. Force majeure simply means a superior force, and this is to say that an event which is beyond the control of a person, an event which a person has no control over, and an event which is not as a result of an act of a person. So if, for example, at the point of carrying on your contract, you do something which is your own doing, something done by you which has prevented you from carrying out your obligation, it is not a force majeure. You can't plead that as an excuse for not performing your obligation under a contract. But if the superior force is such that it is not as a result of your negligence or as a result of your inaction or as a result of your action, it is excused under the law. And some of the factors or some examples of things that can be termed as a force majeure is an outbreak of a disease such as coronavirus. We have an act of God, which includes earthquakes, we have volcanic eruptions, we have flooding and the likes. So also cases where there is a war, it can also be pleaded as a force majeure. Then changes in government policies, changes in law. And an example is the case of COVID-19, whereby governments are about to enact laws to the effect or to the extent that movement has been restricted, people have been told to work from home, and fine, people, the policy on working from home, you agree with me that there are some works that you can't actually do from your house. For example, the supply chain sector, where the contract agreement between yourself and the other parties is to supply some products, or even involves you going out to the person's house to carry out that project. So for example, an engineer who is working on a person's site, you can't expect such a person in the midst of the government laws, guidelines and regulations restricting movement to go all the way to perform obligations under the contract. So these are examples of activities or superior forces that can be pleaded as a force majeure. And one thing about force majeure is that it applies to delay in performance. So when you are pleading force majeure, you are not saying that the party should terminate the contract, but you are saying that the delay in performance of the contract is as a result of force majeure or as a result of a superior force which you have control over. And the way forward on force majeure is for parties to negotiate or review the contract, because where the contract has been duly signed and you've agreed on at the point of executing the contract, you've agreed on a performing date, a commencement date and due date for performance of contract. So by virtue of the supervening act or the act that has limited performance of the contract, parties are advised to renegotiate the terms of the contract. And also, it is good practice when a party wants to rely or plead force majeure as an excuse for non-performance. It is good practice to bring to the knowledge of the other party that the contractual obligations won't will be put on hold or suspended. Fine, everyone knows there's coronavirus outbreak out there, but then there's still a duty on the party who is unable to carry out obligations in the contract to state that the outbreak of the pandemic is going to limit the scope or is going to limit or restrict or even suspend the contractual obligation. So it is good to bring this to the knowledge of the party, and this will give the other party an assurance that you are willing to carry out your obligation in the contract agreement, but for the intervening factor or the supervening factor or the present situation of things in the country, this has been a bar to performance of your obligation in the contract. So if you have any contract obligation which you've not been able to carry out as a result of coronavirus outbreak, I would advise and recommend that you bring this to the notice of the other party. Don't just assume that the person knows that the pandemic is out there and that business activities have been put on hold. I still advise that you bring this to the attention of the other party. So having said that, the other principle of law on frustration of contracts, principle of law on discharge of contracts, or what you can also rely on for non-performance, or where a party is unable to perform its obligations in in a contract agreement. Another principle of law that is also applicable is the principle of frustration of contract. And when you say a contract has been frustrated, this is to say, just like the first measure, that an event has occurred such that a party won't be able to carry on with his existing obligation in a contract agreement. And one notable difference about force majeure and frustration is such that while force majeure is saying that there is a delay when the agreement says you should do this within a number of days or within a number of months or even hours, force majeure is saying that this delay is as a result of this particular act. But frustration on the other side is saying that you can no longer perform the contract. It can be that you can no longer perform, but you have to renegotiate or perform the contract at a later date. And one major example that can easily frustrate a contract such that performance will no longer be applicable is the case of death. So, for example, globally there has been recorded over 34,000 number of cases of people who have had to pass on, or if people have passed on as a result of COVID-19. So let's just imagine that some of these people that passed on, they have existing contractual obligations to perform. They've signed different contracts which require them to perform an act or to do some things, and they've gone to the world beyond. Such contracts cannot be enforced. You can't enforce a contract against a dead person. So automatically such contract is said to have been frustrated. And once a contract is frustrated like that, it automatically comes to an end, especially where the contract is such that requires personal performance by the contracting parties. So where you have an agreement with a person who is to render some services by himself, he is the only one who has the technical know-how on how to enforce that contract. So once the person is dead, you can't enforce a contract against such a person. Also, I've talked about the fact that force majeure is applicable to delay in performance of contracts. Can we then say that force majeure should be or it should be a clause that you should have in every of your contract agreements? Yes, because no one can actually predict what would happen upon execution of a contract or at the point of negotiation of a contract. So it is oftentimes advised that you have a clause in your agreement that provides for force majeure. So this is to say that where there are factors or events which will prevent a party from carrying on obligations in a contract. So it is advised that you have a provision in your agreement that provides for force majeure. However, where you sign the contract agreement and there is an occurrence of an act beyond your control, which will limit or suspend or make you unable to perform your obligation in a contract, the principle of frustration of contract would also apply, because this is a general exceptions to the principle of contracts on performance of contractual obligations. So even when you don't have a clause on force majeure in your contract agreement, the principle of frustration can be adopted in the contract relationship. Having said that, when there is a supervening act, like I said earlier, parties are advised to review the contract. I'm talking about the remedies now applicable when there is a supervening act or where there's something that is preventing a person from carrying on obligations in the contract agreement. So it is oftentimes advised that parties will have to sit together at a round table, or it can be a phone call, but parties can just discuss on the non-performance and talk about the way forward, because it will be fair enough to reasonably agree with someone who has been unable to perform an obligation under a contract agreement at this instance, especially in the due to the outbreak of COVID-19. So it is advised that parties can agree and review the terms of the contract. And while reviewing the terms of the contract, what are the things that you should put in place? This includes the commencement date. You may have to review the commencement date. You may have to review the due date for completion of obligation. And parties may also have to mutually agree and review the financial cost, because there is no gainsaying on the fact that prices of things will go up after this pandemic, because so many economic activities have been put on hold and people would want to regain or recover lost grants and the likes. So parties may have to review the financial cost, because the price of things before COVID-19 might or may not be the same after COVID-19. So these are clauses that parties should consider while reviewing a contract agreement. Also, we have contracts that may not necessarily be important, or parties may not be able to further on or go on with it due to the outbreak of COVID-19. So for example, where before the outbreak of COVID-19 you need a material or you need something at that time, but as a result of the fact that that COVID-19 or the government policies which restricted movement of people, both inter and intrastate, and even foreign journeys have been restricted. So if after COVID-19 some obligations are no longer applicable, so parties may agree to terminate the contractual relationship, and by termination it might require that repaid sum is refunded. So parties can also discuss on what to refund and what not to refund, and that is also that position on um, refund for services that have been paid for or for goods that have been supplied. But it is to be noted that even when a party is saying COVID-19 has been a bar or has limited performance of a contractual obligation, can we say that contractual obligations that are due for performance before COVID-19, can we say that it can be excused as a result of the outbreak of the pandemic? The answer is no. So if you have an obligation in a contractual agreement which ought to have done before COVID-19, let's say you were supposed to do something in an agreement which you've reached with someone, but you've postponed it or you've defaulted in doing it at the time when you were supposed to do it. So if you then plan to do it, let's say at a later week, your plan was that you would carry on your obligation this week, and President Muhammadu Buhari declared the lockdown of Lagos State. You can't treat COVID-19 as a relief from your obligation, because you're already in breach of what is expected of you even before the government policy on restriction of movement and all that. So this is to say that if your obligation was not performed before the supervening act or before the first, or what you seek to rely on as an excuse for non-performance, you can't plead it as an excuse for non-performance. So this is the end of today's section. We've come to the end of today's section, and I will encourage you to join us next week for another edition of our Facebook Live. Next week we'll be talking, we are still going to be talking on COVID-19, but we'll be talking on COVID-19 with regards to employment relationship. I hope you've been able to gather an information, or I've been able to enlighten you on whether or not COVID-19 will relieve you from your obligation in a contractual relationship. Thank you and hope to see you next week.